Hi, I'm Janice Switlo, and today I'm going to take you through some history pertaining to the self-government powers that Canada was able to obtain through history. This is a book published in 1958. It's called A Short History of Canada, and I'm going to make it even shorter and point out some of the key aspects and time frames of when things were happening. And here's two things I'm going to front end with that I hope you take away from this. One, there's no mention of Indians. There's no mention of Indigenous nations. Why is that? Well, remember, in 1958, there had been no legislation yet passed by Canada deeming Indigenous nationals to actually be Canadian citizens. They were still at this time understood to be foreign nationals. They were not governed by any Canadian law. Now, everyone's going to say, okay, Indian Act. But I'm speaking about who is contained within the governance of Canada. The Indian Act's a separate thing, because remember, that was imposed on Indigenous nationals and is not part of Canada's development of its governance system. So it was not until 1960 that Canada said, gee, how are we going to get, roll these people in? How are we going to do this? And keep in mind, they were busy fighting with, how do we work with the French and roll them in better? But remember, the French were defeated in a war. Indigenous nationals, there were no wars with these Indigenous nations. There were later treaties entered into. Treaties, again, nation to nation. And I won't get into a lot of that right now, but clearly, as of, 1958 in this, accurate history of Canada, it was understood Indigenous nationals were of their nations, not of a nation called Canada. And that's important to remember. So this is going back to when Lord Elgin was the Governor General of British North America, and his period of governorship in Canada was from 1846 to 1854. This was a time of serious political and economic crisis. His successful negotiation difficulties confronting his administration constitutes an important turning point in the history of Canada. Elgin practiced a policy of conciliating the French and integrating them in the Canadian political system. Now remember, the Canadian political system does not include foreign nationals, Indigenous nationals. They're part of their own political system. So he was anxious to satisfy that. So why am I pointing this out? Conciliation, isn't that awfully close to reconciliation? Isn't this exactly what Canada is now trying to do, having successfully, for the most part, done this with the French, is now turning attention to finishing off, Indigenous nationals so that they will no longer be seen in any capacity as foreign nationals. So deeming individuals to be citizens does not do anything in terms of their original nationality. They still carry that. So Indigenous nationals still exist at 1960 and onwards, even though they were deemed to also be Canadian citizens. Why did Canada have to pass that? Because the existing immigration laws didn't cover them. They weren't coming to here. They were already here. This is their land. There's treaties, etc. So a lot of complications. What do? We'll just call them Canadian citizens. There was no matter of Indigenous nationals asking and applying to become Canadian citizens, although under the enfranchisement situation, that's exactly what they were doing, except a few took that up. And why was this successful, this conciliation? It says, well, from this time on in Canadian history, there was always a considerable number of French politicians willing to cooperate with Anglo-Saxons. So, again, this is not Canada's first rodeo. They're applying what worked before, and they're applying it to Indigenous nationals today, hoping to achieve the same outcome, only it's very different, and you'll see as I discuss this later. So it said to some extent, the British North America Act that came into effect on July 1, 1867, to some extent it provided Canada with a written constitution, although its working depended upon many precedents and statutes which Canada inherited from the British political tradition. Now remember, Canada has inherited the obligations, to fulfill the obligations of the treaties, which remain in full force and effect, having been fully implemented. When you speak of implementation of a treaty, you're speaking about it coming into force. What steps are necessary to be completed by each nation to that treaty in order to say this treaty has now been implemented? All those steps have been done. The treaties still remain in effect and they bind the Crown. And Canada, through the course of its self-government, has inherited this requirement to fulfill the obligations under treaty. But Canada did not become a successor state through any of the course of this issuing of self-government from the Crown. It's important to understand that. The treaties remain with the Crown. They're still in full force and effect, unless Canada is able to get the Indigenous nationals to walk away and abandon who they are, what they have, and what they have includes those treaties. Basically, trying to entice Indigenous nationals to accept self-government as delegated by Canada, which, as you'll see through here, is still in the process of nation building, is still, baby steps in exercising its self-governance. I find it quite arrogant on the part of Canada to suggest that it is the expert and will dictate how and when and in what form and shape Indigenous nationals will exercise their own governance. It's about control and bringing and destroying the Indigenous nations and bringing the remnants underneath Canada as domestic ethnic minorities. Now, just pointing out, and I'm skipping around, you'll sort of see commentary on this later. The Liberals were responsible for one important measure, the establishment of the Supreme Court of Canada in 1875. Now, I'm not going to get into it here, but there's a lot of controversy over the legitimacy of the Supreme Court of Canada. The Liberals established it. This is not, you'll see throughout the history of Canada, the people aren't actually agreeing to what's going on in terms of constitutional amendment and acceptance of self-government. It's always done by the elites, by those in power. And Liberals have been key on doing that. I'll do a separate episode on what that controversy involves regarding the Supreme Court of Canada. Okay, then there is some, the issues that arose that led to further delegation of self-government. Another cause of dispute was the power of the Dominion government to disallow provincial legislation. Between 1867 and 1893, conservative governments in Ottawa acted upon the assumption that they could disallow provincial acts on the ground that they were unjust or oppressive, although otherwise within the competence of the provinces. Now this is important because BC always went against the grain in terms of the Crown obligations in dealing with Indigenous nations. It's from BC that we have all these different, they're not so different, this trick or treaty, as I first wrote about it, proclaiming that these are actually treaties, but they're actually land claims agreements, etc. Always trying to undermine and do things different because BC just didn't want to be bound in the way that Canada has been structured through treaties. And wanted to change the way the Crown does things. So conservatives here were acting that, hey, that's just not fair, it's not just, it's that's oppressive, so we're not going to allow that to happen. Under the Liberals, who took office in 1896, this policy was abandoned. You see the setting of stages, going back. And in 1875, also when they put in the Supreme Court of Canada, Canadian Minister of Justice Edward Blake persuaded the Imperial government to recast the commission and instructions to the Governors General. It was before that time that, if anything, according to the Colonial Laws Validity Act of 1865, Canadian legislation, if repugnant to legislation of the British Parliament, was null and void to the extent of the repugnance. For a number of years, Canadian self-government was also limited by the instructions and commissions issued by the Imperial Parliament to the Governors General. They were ordered to refuse assent to bills dealing with an enumerated list of subjects. They were also instructed to exercise their own personal judgment in the pardon of offenders condemned to death. So again, Liberal Party in government took aim at those checks and balances. It says, in other respects, Canada's position was much the same in 1914 as in 1867. The doctrine of repugnance still applied to Canadian legislation. The amendment of the Constitution remained in British hands. The establishment of the Supreme Court in 1875 had not altered the position of the Judicial Committee of the Privy Council as Canada's final court of appeal, despite the efforts of Minister of Justice Edward Blake to have appeals abolished. Canadians had played some part in the negotiation of treaties, but Canada had not secured control of high policy involving the ultimate decisions of peace and war. When Great Britain declared war on Germany in 1914, it was taken for granted in Britain and Canada that the Dominion was at war also, the Dominion of Canada. One of the difficulties that had developed during this time was that it was partially a result of vigorous protests from Sir Robert Borden in 1916. He had become dissatisfied with the failure of the British government to keep Canada informed respecting the conduct of the war. They were supposed to be included in an Imperial War Cabinet that was established in 1917 to discuss these policy matters. So resolutions then adopted at the Imperial Conferences of 1923 and 26, particularly the Balfour Declaration of 1926, went far towards recognizing the autonomy of the Dominions. Not independence, but autonomy of the Dominions. The Statute of Westminster of 1931 established the principle that legislation of Canada and the other Dominions was no longer null and void if it conflicted with legislation passed by the Parliament of the United Kingdom. Appeals from Canadian courts to the Judicial Committee of the Privy Council were abolished in criminal cases in 1935. Delivering the judgment of the Judicial Committee of the Privy Council in British Coal Corporation versus the King, Lord Sankey stated that he saw no reason why the federal parliament could not, in view of the Statute of Westminster, abolish appeals in criminal cases. Appeals in civil cases were abolished in 1949. In 1949, by an amendment to the British North America Act, the Dominion Parliament was empowered, they didn't pass it themselves, Britain did this, was empowered to amend the Constitution in matters affecting the Dominion government only. After 1949, the only important limitation on Canada's complete self-government was the function of the British Parliament to amend the British North America Act in matters affecting both the Dominion and the provinces. In foreign policy, between 1918 and 1939, Canada was mainly occupied with the establishment of her status as an autonomous country. Otherwise, the Dominion did not take a strong stance on any of the matters going on. In 1945, Canada was entered into the United Nations, and it was permitted. Was not attended by the isolationist sentiments which had weakened its role in the League of Nations. Now keep in mind, Indigenous nationals were well ensconced in residential school systems at this point. They were busy, killing the Indian within the person, as that policy purported to try to be doing. However, in the atmosphere of controversy between Russia and the West in the 1945 to 1949 period, Canadians gradually lost faith in the United Nations as a guarantor of world peace. It's kind of curious as to why so many Indigenous nationals feel there's so much to be gained by approaching the United Nations. Now, again, emphasizing, remember I said that Indigenous nationals were not considered citizens, and they weren't citizens of Canada at the time this was written. So here it says, at the time, this is 1958, since Canada is one of the world's major industrial and commercial powers, its population, some 15 million, appears surprisingly small. It is composed of people of British descent, French Canadians, and Europeans in the approximate proportions of 5, 3, and 2. The last group consists chiefly of Scandinavians, Germans, Italians, Netherlanders, Poles, and Ukrainians. To a large extent, they are the immigrants who have come to the country since 1900. The Jewish population, a minority of 200,000, have made a contribution to Canada's development out of all proportion to their numbers. There is no accounting or recognition of Indigenous nationals because they are not part of Canada, to repeat. They are part of they remain solely of their own nations. The Canadian system of federalism has made possible reasonably amicable relations between French and English. Conflicts of interest between the different regions of Canada have been in large measure resolved within the framework of the Federation. Framework, here we have, again, similar concepts. They are applying, as I'm saying, they're applying these old strategies that worked for bringing together French and English, and now trying to get, Indigenous nationals to come under that. The French and the English have not always agreed on the issue of civil and religious liberty, but loyal acceptance of judicial decisions has always enabled them to settle their differences. Loyal accepting of judicial decisions. This is why I caution that when you move into that arena of relying on domestic courts, you're playing their game, you're exhibiting, and remember the Section 35 doctrine is very powerful for saying you admitting and representing you're not of another nation, you're only Canadian, and you're only a domestic ethnic minority. And any quote-unquote rights are what the Canadian government, if you will, the Canadian court, being part of the Canadian government, is willing to give you. Canadians are proud of their various racial and religious traditions, but they have come to regard themselves primarily as Canadians. This is 1958. They are determined to exist as an independent people and develop their own culture. So here you have, again, the arrogance, right? Here you have Indigenous nations surviving for thousands of years, well-developed cultures, well-developed self-governance, and Indigenous laws, the whole thing, right? And here you have this baby saying, I know how to do it best, and I know how to do it best for you, and that's because, I'm white and I'm Christian, and Bible says that you're just, and the popes have said you're just beasts of the field, so I'm going to take care of you and do for you, and now delegate to you forms of governance, as I said earlier in this episode, forms of governance that I think is best for you. Put it into context, put it into historical context and time frame. Okay, I'm going to leave it at that. I've got some other things to describe from this particular book, but I'm going to set that out in separate episodes to make this a little more easy to digest. Thank you for your time.